For most of human history, if a ruler wanted their neighbor's land and had the army to take it, they simply took it. At the time, initiating a war wasn't a crime. It was a perfectly legal, often celebrated tool of statecraft. International society provided a legal framework that validated these invasions. Under the Right of Conquest, taking territory through brute military force granted the victor lawful ownership of the land. In this era, winning the battle meant owning the map. To us, the idea of legal conquest sounds like a contradiction. We view unprovoked invasions as a violation of the global order, yet for centuries, that was the standard. Before the 20th century, international law only focused on how you fought, setting rules for treating prisoners or diplomatic envoys. It never questioned a leader's basic right to start the fight in the first place. That tolerance for war was destroyed in the trenches of World War I. The staggering casualties and the sheer scale of mechanized horror made it clear that civilization could no longer treat conflict as a routine policy option. In 1928, nations gathered to sign the Kellogg-Briand Pact. It was the first major multilateral treaty where governments explicitly agreed to renounce war as an instrument of national policy. The treaty was a breakthrough on paper, but it was essentially toothless. It declared war illegal without creating any enforcement mechanisms or any concept of individual criminal liability. When World War II ended, the Allies faced a dilemma with no legal roadmap. They had captured the men who orchestrated global devastation, but under existing laws, the act of starting a war wasn't technically an individual crime. To hold these leaders accountable, the international community had to write a new category of law, one that targeted the architects of the war, not just the soldiers on the ground. This gap was finally addressed at the International Military Tribunal in Nuremberg. Prosecutors introduced a novel charge, crimes against peace. This penalized the planning, preparation, and waging of an aggressive war. The tribunal's judgment remains one of the most famous in history. It declared that initiating a war of aggression is the supreme international crime because it contains within itself the accumulated evil of the whole. Nuremberg shifted the legal blame from the abstract concept of a state to specific individual human leaders. Today, the ad hoc tribunals of the past have been replaced by a permanent court, the International Criminal Court in The Hague. Even so, finalizing the exact legal definition of aggression took decades of intense debate. It wasn't until the 2010 Kampala Review Conference that nations finally reached a consensus. This infographic shows the modern crime is built on two pillars. The first is the act, a manifest violation of the UN Charter, like a military invasion, bombardment, or annexation. The second pillar defines the perpetrator. It includes a leadership requirement to ensure accurate application. This means that lower-level soldiers and ordinary military personnel cannot be prosecuted for the crime of aggression. Instead, the law provides a surgical definition designed exclusively to target the presidents, prime ministers, and generals who have the power to actually shape state policy. If the law is this precise, why aren't all the leaders who launch unprovoked attacks sitting in a cell in The Hague? The problem is jurisdiction. The ICC can only prosecute aggression if the leader's home state has voluntarily ratified the specific amendments to the Rome Statute. There is one way around this. The UN Security Council can refer any situation to the ICC, granting the court power even over states that haven't signed the treaty. But the 5 permanent members of the Security Council hold absolute veto power. This effectively allows them to shield themselves and their global allies from any prosecution. This creates a system where the law is often applied to weaker states, while the most powerful nations remain legally untouchable. There is also a more basic weakness. International courts have no police force. They rely entirely on member states to physically execute their arrest warrants. This gap between the law and the reality of enforcement feeds a deep cynicism, the sense that the international order is just a cover for the old rule of might makes right. Yet the historical baseline shows how far we have traveled. In less than a century, we have moved from a world where conquest was a celebrated sovereign right to one where it is, for the first time, a codified international crime. the legal definitions to prosecute the unthinkable finally exist. The challenge for the 21st century is whether the global community can muster the political will to actually enforce them.